This is just a short overview of what you're going to encounter in this course on criminal procedure. One thing you will be doing as you walk through the chapters and through these modules is you will be looking at various stages of a criminal case. Everything from the investigation on to when a prosecutor makes a call about whether or not to take charges, might present something evidence to a grand jury, whether that grand jury finds probable cause and issues an indictment, or rather no bills someone. After that, whether or not the defendant in a criminal case pleads guilty or not guilty. And if someone pleads guilty, it might be to the charges as stated, or it might be to a lesser offense as a result of a plea bargain. It might be the actual offense with a guarantee that the prosecutor will seek no jail time, or 2 years instead of 20, or 20 instead of life. So plea bargaining is a big role. You will read about that and learn about that. The trial itself, the verdict, whether for the state and therefore a guilty verdict or a verdict of not guilty in the defendant's favor. If there's a guilty verdict, there may be an appeal by the defendant to the Court of Appeals or to a Supreme Court. In Texas, that is the Texas Court of Criminal Appeals. We actually have 2 Supreme Courts. Or if it is a United States Constitution question, it might go beyond the state courts, and it might go to the Supreme Court of the United States. Now, that's not a guarantee. Obviously, the Supreme Court of the United States gets to set its own docket and gets to hear what it wants to hear. And so the best that one can do is perhaps go to the Fifth Circuit or another federal circuit, and there are some direct appeals, and then there are some writ appeals, writs of habeas corpus, all sorts of interesting questions for you to encounter as you are reading through the text and going through the modules. But one thing that I think will be very helpful to you is to always keep in mind the text of the Constitution. Now, in this case, we're going to narrow that, for the most part, to stretches of text found in the Bill of Rights. And I want to take a look with you briefly at some of the language, just sort of a slow, close reading of 3 of the amendments. One is very short, and certainly all the amendments might have some participatory role in the rights. Now, your textbook says Amendment 3 that has to do with quartering soldiers, and it reads, "No soldier shall, in time of peace, be quarantined in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law," end quote. And your textbook says this is a relic of history and has no relevance to the current law enforcement. That's false. It does have relevance to the law enforcement officer. Now, it may not be direct, but the right to privacy that you will read about, which is foundational for law enforcement, in the sort of the watershed case on the right to privacy, the Third Amendment, in fact, was used as evidence that there is, in the sort of the shadows, the penumbra of the Constitution, there is a right to privacy, though not explicit. Now, that's probably not that important to a police officer on the streets, a detective, but it is true. The Third Amendment, even though it has really no direct relevance to law enforcement, does have indirect relevance because it supported, in some part, this right to privacy that was found by the Supreme Court. So all of the rights are important. Your First Amendment rights are important. Second Amendment is important. So is the Third. But one of the most important that you will come across is the Fourth Amendment. So let's take a look here. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now, I have made some slight variations here. I have some numbers, 1, 2, 3, and 4, persons, houses, papers, and effects. I have some bold, this is the right of the people, and I have a few italics. If you look here, unreasonable searches and seizures. So this is just to draw your eye to the words. I won't do it in the others, but just pay attention here. The right of the people, that is a huge statement. This is the right of the people. It is not necessarily given by the Fourth Amendment. It is acknowledged by the Fourth Amendment. There's a right of the people. What's that right? Well, to be secure in various things, person, houses, papers, and effects. And it says, this right shall not be violated. And then no warrant shall issue but upon probable cause. Now, probable cause is going to show up. In fact, there is a whole short video on probable cause, a chapter, because it shows up in various stages of the criminal justice system and parts of a case. So we have everything from a warrant to a warrantless search. We will talk about that in another video. But probable cause, this is its source, Amendment 4. Now, moving along to Amendment 5, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Now, you may gloss over the time of war, Army, Navy, Air Force, Marines, Coast Guard, militia, Texas Guard language, essentially. It's important. You might say, well, that last part, private property be taken, eminent domain, yeah, that's a different part of the law. It's not criminal procedure. Well, there's actually arguments, not everyone is on the same page, about civil asset forfeiture. And there are some arguments made that potentially violates the Fifth Amendment. I'll let you make that call, and if you're interested in it, I'll let you do that research on your own. But this amendment, Amendment number 5, has a lot of protections. Right? It gives you a right to a grand jury. It protects you against double jeopardy. There's a protection against self-incrimination, and this is also something that happens in civil trials on multiple occasions. I have had a civil deponent, that is person who is being deposed. It's a person essentially on the witness stand, sworn in, but not actually in court. We do it ahead of time so that we can capture that evidence, and then also that we have time and there's no gotcha in the actual trial. It's a judicial efficiency, but it also can help resolve cases, especially in civil cases when there's a dispute. If we get good witness testimony ahead of time, that means sometimes we don't actually have to go to trial because the parties can agree on something based on that testimony, but it has the same weight as if you were in the witness stand under oath with a jury. So people have said, I'm going to plead the Fifth on that. Sometimes that's because, let's say there's a personal injury case and the plaintiffs are suing the defendant who was a driver who was allegedly drunk. I don't mean just merely had a beer, but was intoxicated, illegally driving, and maybe killed someone. Well, that would be a civil case, a tort case for wrongful death. At the same time, the local district attorney's office might also be charging that defendant for some sort of homicide. And so sometimes there are parallel tracks going. The same defendant, one plaintiff is the state of Texas, here in Texas. The other plaintiff is the injured party or the estate or the survivors, if the legislature allows, for instance, a spouse or child or a parent to stand in and file a lawsuit. So people do plead the Fifth, even in civil cases. Those are interesting cases to read about. In our course here, we're mainly going to be talking about criminal cases. The final amendment is the Eighth Amendment. This says excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. Now, this doesn't sound to me, when I read it, like it's going to be something a law enforcement officer is going to have to deal with on a daily basis. And that's probably right. Of course not. These are about setting bail so that someone can be relatively free while there's a further investigation or trial pending. Excessive fines. We can't give someone $1 million fine for speeding 5 miles an hour over the speed limit. But the cruel and unusual punishment, the reason why I put this one in here, even though it's an overview and I'm looking at the main amendments, which would be 4 and 5, this one is interesting to show you that although law enforcement officers may or may not care about this one on a daily basis, it does matter in the system. And this is everything from bail to the beginning, before trial, to after trial when punishment is pronounced, when there's a sentencing, for instance. And what does cruel and unusual punishment mean? Now, personally, I can't tell you what the percentage is, but a high number of appellate cases that I have responded to alleged cruel and unusual punishment. It's too long in prison, or you shouldn't be put in prison for this or for that, or this is just too much time in prison. I have never had anyone argue that it was unusual, but I have never had someone successfully argue, at least in the Court of Appeals, that someone was sentenced to something that was excessive or cruel and unusual. But they allege it. It is perhaps even a good faith argument. If someone were caught speeding and got 25 years in prison, you might wonder what is going on. That seems on its face like that is unusual punishment and cruel to take that amount of life, that time away from someone for speeding. But what if they killed someone? 25 years doesn't sound necessarily that long. Well, what if they were driving while intoxicated but didn't injure anyone? So I had a case where someone was driving while intoxicated, was found guilty, and was sentenced to 30 years. He didn't cause any property damage. He didn't cause any human damage. So that may befuddle you to some degree, but in that case, cruel and unusual punishment was alleged, and there were multiple factors in that case that would make it less crazy sounding, if it does sound crazy to you. All right, so as you're looking through your text, as you're going through the modules, keep in mind that the sources of rights, everything from the federal constitution to state constitutions, the amendments, that we are not just looking at the text like what we just did, we're also looking at Supreme Court interpretations. And you will see throughout, almost every other page has some reference to the Supreme Court case, and that is really what runs criminal procedure classes in law school, because as the Supreme Court makes calls on given situations, that creates precedent that must be followed by everyone, all the judges, all the lawyers, and all the police officers.